Hello, everyone. Good day. Thank you for tuning in. This is Nick Raquel. I'm uh, trying to go live here in New York. And again, magandang araw po sa inyong lahat. Hindi ko alam kung saan kayo ngayon. Whether it's good morning, good afternoon, good evening. But I'm here again to actually share some updates, or at least just sharing some concepts about U.S. immigration. So for today, ang topic natin will be about the J1 visa. Okay? And in particular, we're gonna be talking about anong mangyayari after the J1 visa has ended in terms of people who are already in the United States. So, for people who are still planning to actually have or to enjoy coming to the United States on a J1 visa, manood na rin kayo, at least alam nyo na kung anong magiging sitwasyon nyo pagdating dito. So I'm not so sure if my volume is okay. If you can actually just give me a feedback very quick before I can jump into the details of our conversation or the topic today. So mag-scroll lang ako kung naririnig nyo ako. If you can actually just give me a feedback at that point before I'll start. And again, I have difficulty with my YouTube live. So if yung mga naghihintay sa akin sa YouTube, if you could actually just watch me on Facebook, and then I would really appreciate that. Sandali lang, give me a second. Okay. Let's start with the first topic. So again, after J1 visa options, whether you're gonna do H1B or green card, change of status, or you have to go home. You're gonna go the situations like that. So kung kunwari you are on the first year, second year, third year, fourth year, or fifth year, because I've been receiving a lot of inquiries from our J1 teachers, and minsan yung iba misinformed, mali yung strategy nila, they end up having to go home instead of being approved of the 2-year extension. But again, this is the intention of this Facebook Live, at least to educate you what a J1 visa means and what can you do to actually be able to maximize your stay in the United States. So again, I am Nick Caracal. I'm Facebook Live on here in New York. I am an immigration attorney, and we've been dealing and we've been having success as far as helping our teachers obtain their waivers to be able to at least stay legally here in the United States and get their green card. So medyo marami-rami ngayong nanonood, so I may not be able to answer all questions, but I will try my best to answer your questions, guys. Just quick disclaimer, this don't take my specific instructions, advices to you as an advice, as a lawyer, a client relationship, but I will try to respond to your generic questions as generic as I can. But if you need more information, or if you want to discuss in more detail about your case, feel free to send us a message or set us an interview, a consultation, so we could actually discuss that. So we'll start with general concepts. So a J1 visa is actually a type of visa that the U.S. Give to foreign foreigners who actually agreed to enter or participate in an exchange program between two countries. In this case, the Philippines and the United States. So again, for the purpose of teaching, instructing, studying, or on this and the likes. But for this particular Facebook Live, we're gonna talk about the teachers. So the purpose here will basically be teaching, and of course the exchange of two cultures, right? So again, here are some examples of the J1 visa holders, the professors, students, trainees. But again, as I mentioned, we're gonna talk about the teachers just for today. So if I'm gonna see some questions that related to the teachers, I will skip through them because again, this tonight is for the teachers. Okay, duration of stay. Once you have a J1 visa, you are allowed to stay in the United States for a maximum of 5 years. Though initially you will be given 3 years initial visa after your interview at the embassy. Then you enter the United States. You're allowed to enter the United States 30 days before your program starts, and once the program ended, you are actually allowed to stay 30 days still in status without incurring unlawful presence, right? So it depends now on your J1 sponsor or your training institution, in this case, a school, whether they give you a 1 year extension or a 2 year extension. It's their strategy, but again, your duration on a J1 visa is you have 5 years. So you could basically enjoy 5 years of legally working in the United States once you receive your J1 visa from the embassy. The nature of a J1 visa, it is an exchange visitor visa. It is not an employment visa. So then again, once you agree to participate in a program, you understand and you agree that you will be going home to your home country of residence or your home country of nationality, in this case in the Philippines, because that's the nature of the J1 visa. Okay. It also applies to the dependents. So you would be able to bring your spouse and, of course, your unmarried children who are below 21 years old. And then once they are in the United States, they would be able to apply for a work permit. So the good thing about that is at least they will be able to have a social security number, and that they would be able to work in whatever field or profession that they want to go into. A work permit has no restriction in terms of the nature of the job that you will be going into or the job that you will be wanting to do or perform in the United States. Unlike the J1 visa holder, though, the principal applicant. So in this particular case, the teacher, it is employer specific. So let's say you have two schools, but it's only school A or district A that actually sponsor your J1 visa. You can only work for employer A, and if you would want to work in employer B, then you have to have a different type of visa to be able to do that. But again, on a J1 visa, it's a very restrictive type of visa. You can only work for the person or entity that sponsors you. And again, the good thing about that is you'll be able to bring in your dependents, your spouse, your unmarried children below 21 years old, and they will be able to help you financially because they will be allowed to work. Restriction in general, teachers in general, they are subject to the 2 year home residency requirement, or commonly known as INA 212E. So this is the Immigration Nationality Act. It only means that after your 5 year visa or after your J1 visa program expires, you have to go home to your home country of residence or your home country of nationality and stay there for 2 years before you could actually come back to the United States, either to accept for an H1B visa, an L1 visa, or receive a green card. So we're going to talk about H1B, L1, and immigrant visa in a bit, but that's basically what it meant when we actually say INA 212E or two home residency requirement, because I will be repeating this concept as we move along with the slides. However, even if by rule they are supposed to be staying in the United States for maximum of 5 years, but the law allows them to apply for a waiver. And the most commonly used waivers, though, are the no objection statement, or you call the NOS. Whenever the applicant is married, a U.S. citizen, or a green card holder, or if they actually have a U.S. citizen child for the duration of their J1 visa. So in some cases, though, even if the teacher was able to marry a U.S. citizen or a green card holder, however, they were previously married in the Philippines and they got divorced in the United States and marry a U.S. citizen or a green card holder, they still could not apply for a no objection statement. And we will talk about what no objection statement in a bit. Uh, but they can apply for exceptional hardship. The primary reason of that, though, because divorce in the foreign divorce is not recognized in the Philippines. So as far as the Philippine government is concerned, they are still married. And part of the requirements when you apply for the no objection statement is the CENOMAR or the certificate of no marriage. So if you are still considered married in the Philippines, you will not be able to comply with the no objection statement requirement. That's the reason why you cannot apply for the NOS. However, you can apply for the exceptional hardship on the part of the qualifying relative. In this case, your U.S. citizen husband or wife or a green card holder husband or wife. So again, I put a note here. No person who obtained divorce in the United States, and I will maximize my screen here so you could read through my slides. No person who obtained divorce in the US cannot apply for NOS but may apply for exceptional hardship. Okay. If you are subject to the 2-year home residency requirement, you will need a waiver to obtain an H-1B. H-1B is for the specialty occupation, any position that requires a maximum of a bachelor's degree and requires specialty skills or concepts, or then you might be able to apply for H-1B. L-1 is for the multinational executive visa. Uh, this applies for a type of visa where a U.S. company has some affiliates outside the United States and they intend to actually transfer some of their employees for training purposes or for development purposes. And then again, we talk about the immigrant visa. So I'll talk about this a little bit. Kasi pagdating nyo sa United States, and of course, in general, as far as I am concerned, I've heard a lot of employers that, Nick, we love our teachers, we love the Filipino workers, and we would want them to stay with us. The problem is, their visa is about to expire and we don't know what to do. So again, before you waste your time exploring and put your emotions into it, when there is an employer or any person or entity interested to offer you a job, whether to your spouse or to your children, uh, do not waste your time spending planning that you're going to stay in the United States without having to go home for 2 years if you don't obtain a waiver. So you need a waiver before you can get an H-1B. You need a waiver to get an L-1 multinational executive waiver, and you need a waiver to apply for a green card. So even if your employer is willing and loving you to stay in the United States, unless you can get a waiver, you cannot get those type of visas. So I just have to reemphasize that so you don't waste your resources and money. Okay. And then the 2HRR, what it meant is that you have to return and be physically present in the last country of residence or your country of citizenship. So let's clarify that. So let's say you obtain your J1 visa in the Philippines and then you stay in the United States for 5 years, then you have to go back and they actually ask, Nick, can we actually work in the Canada to at least stay there for 2 years, then come back to the United States? No, you cannot. If you obtain your J1 visa in the Philippines, then you have to complete your 2-year home residency requirement in the Philippines. However, if you were a national of Canada, let's say, or a resident in Canada, or you were working in Canada when you obtain your J1 visa, once your J1 visa expires, then you can go back to Canada and comply with the 2-year home residency requirement there, or you can go back to the Philippines and complete your 2-year home residency requirement in the Philippines. So that's what it meant, the 2HRR ang ibig sabihin, no? Okay, so how would you know now if you are subject to the 2-year home residency requirement? So ibig sabihin na, nakuha ko na yung J1 visa ko, paano ko malalaman kung uuwi ba ako after the J1 visa or not? So if you had applied for a J1 visa and for the interview at the embassy, then take a look at your stamp, we call. Let me maximize this. So makikita mo dito sa baba ng ano, so nakikita mo dito J1 visa. So that's a J1 visa. And then there's an annotation at the bottom part of the stamp that says the bearer is subject to section 212E. So if you see that, then you are required to go home to your home country of residence after your J1 visa expires. So there is also a form called the DS 2019. This is the certification of eligibility for exchange visitors. Mayroon din nakasulat doon na yung whether or not you are subject to or not subject to 212E. So at least you have an idea of knowing paano malalaman kung subject ka ba or uuwi ka ba after your J1 visa expires. So the same manner in the lower portion here, makikita dito na the bearer is not subject to the section 212E. So ibig sabihin nun, hindi mo kailangan ng waiver if somebody will offer you an H1B, an L1, or an immigrant visa. And we will talk about some examples of that in a few seconds. So again, to reemphasize what it meant kung subject to INA 212E, it only means that you need to go home to your home country after the visa expires, or you need a waiver to obtain an H1B, L1, or an immigrant visa. And that restriction does not apply only to you. It only applies to your husband and to your children who obtain their J2 visa. Ang tawag sa kanila J2 pag dependent sila. And they cannot accept an H1, they cannot accept an L1 offer or an immigrant visa unless you obtain a waiver. But if you're not subject to, you can change status. So let's say, patapos na yung visa mo and you would want to change to a student visa or a tourist visa temporarily or accept a working visa. If you are not subject to INA, go ahead because you could actually obtain that without a problem. And again, if you are not subject to and your dependents are also not subject to, then good for you, no? Kasi tuloy-tuloy yung pagstay nyo sa United States. Okay, so what are the factors being considered for the government to say whether you are subject or not subject to the 212E? So ito yung dalawang factors na binabasihan. You receive government funding, program funding, right? So ibig sabihin, yung program na ina-attendan mo or you are participating in is partially funded or wholly funded either by the Philippine government or the US government, then chances are you will be subject to the 212E, no? And then the second component of that is if the profession that you are participating in is part of the skills list program. So for the Philippines though, if you actually have the copy of the list under group 13, under education, kasama na dito yung elementary teachers, high school teachers, or yung mga special ed teachers natin, generally speaking, they are part of the country's skills lists. So, generally speaking, we could actually safely say that yung mga Filipino teachers natin should be subject to the 212E. But of course, alam natin na may mga taong walang tatak na subject to the 212E. So, let's talk about that in a bit. No? So, again, majority of the programs that we've actually seen, they are not funded partially by either by the Philippine government or the U.S. government. They are actually being funded by the employer or by the training institution. So in that regard, they may not be subject to the 212E, right? But again, those are the two factors being used for the government to determine whether you are subject to 212E or not. Okay? And then, who determines whether you are subject to the 212E or hindi? Initially, it's actually the Department of State, Consular Officer, and the Department of Homeland Security that actually determines whether you are subject to the 212E. So, yung Form DS 2019 mo is actually coming from the Department of State. So, your J1 sponsor will prepare your DS 2019, and then based on the program, they will be able to determine whether you are subject to or not subject to, no? However, the final the final entity or agency that determines kung talagang subject ka or not subject ka to the 212E is basically the Exchange Visitor Program, AVP, and the Bureau of Consular Officers. So how does that work? So once you apply for a J1 visa, your J1 program will prepare the TS 2019 and then forward it to you, and then you will appear for interview at the embassy, and then the embassy will give you a stamp or a visa na ilalagay sa passport mo, right? So, why is it that sometimes nagkakamali yung stamp na yon? Without deliberate intent na magkamali yung officer. Sometimes kasi when the consular officer receive your DS 2019 and the papers that support that, may mga kulang na information that the officer may not actually know, and then by mistake they would be able to say, oh, you are not subject to the 212E. However, pagdating mo sa Amerika, and then you change status or then you extend. So there's a lot of cases where the J1 teacher is given a 3-year initial duration of their J1 visa, and they are not subject to the 212E. However, pagdating dun sa 2-year extension, nabigla na lang sila na, oh, suddenly I am now subject to the 212E. That is actually within the rules, because the officer handling or reviewing or analyzing your 2-year extension has the authority to go back to your program details, and then they could actually change your visa classification, whether you are subject to or not subject to 212E. So, ang ginagawa ngayon, whenever you apply for an immigration benefit, ibig sabihin lang nun, you are a J1 visa holder, and then you try to change status, apply to H1B, or you apply to an immigrant visa, the officer could actually change that classification from not subject to subject to, or from subject to not subject to. So in by procedure, what they do is they ask for an advisory opinion from the Department of State to say, hey guys, I have an applicant here who is applying from J1 to H1 or J1 to a green card, but I'm not so sure whether this is subject to the 212E. And then again, the AVP or the Bureau of Consular Affairs will go back and give you the appropriate classification. So that's how it actually works as far as determining whether or not you are subject to the 212E. Okay. By the way, before I'll proceed, I actually just created my YouTube channel. So if you want to receive more information or updates on U.S. immigration, please subscribe to my Caracal U.S. Immigration TV. Okay. So before I proceed, let me see if we have questions here. Okay, klaro pa naman kasi nasa concept pa tayo. Okay, so wala pa akong nakikitang question dito. 3 years we have here from, give me a second. This is from Daryl Nars Cortez. 3 years, ibig sabihin, after po ng 3 years, need na mag-waiver, or after po ng 5th year? Okay, very good question, but we will go over year by year kung kailan ka mag-a-apply ng waiver. So, ang ibig lang sabihin ng 3 years doon, initial lang yan, right? So, by law, you're allowed to stay maximum of 5 years in the United States, but the U.S. Embassy will give you initially 3 years lang to stay in the United States. Then, normally 3 months before your J1 visa expires. But as far as we've seen, 6 months pa lang, 5 months pa lang, inaasikaso na ng J1 sponsor mo or yung training institution mo yung extension mo ng 2 years. So then again, most of the training institution or J1 program that we've seen, automatic nila ini-extend ng 2 years, but there are some institutions that would only give you 1 year extension at a time. But that's basically what 2 years mean, okay? Maghanap pa tayo ng mga questions dito. Hindi na ba pwede ang IJA? Okay, I will show this. Ma'am Tina, we've actually, again, if you actually look into the website of the U.S. Department of Education, they are still very vocal in saying that we are not accepting IJA waivers for teachers for now. I am now basically trying to communicate with the Bureau of Interior. Ito yung mga Indian schools natin. Because they are also an IJA participant, we haven't received a response yet. But again, as far as your question is concerned, no, they are not accepting IJA waivers. For Bain Williams, what is DS 2019 is subject to, but visa says not subject to the 2-year home residence requirement. Okay. So, whenever you apply for an immigration benefit, ibig sabihin nun, and we've seen a lot of these, right? So, ito yung example nga na nagkakamali lang, right? Because ideally, dapat yung taong naggumagawa ng stamp mo should follow what is written in your DS 2019. Because the DS 2019, the certification of eligibility mo, is actually being prepared by the J1 sponsor, and it was reviewed and analyzed by the consular officer, and then dapat doon babasihan yung stamp. But minsan nagkakamali, right? But again, initially, the officer at the port of entry will just look into your stamp, whether it's subject to or not subject to is not relevant at that point. Nagiging relevant lang or importante yung question na to the moment na magkakaroon ka na ng extension or now you are trying to change status from a J1 to an H1 or an immigrant visa or any other non-immigrant visa. So then the officer has the opportunity to correct whether or not the classification is subject to or not subject to. Okay. So again, thank you for the engagement. I'm just trying to answer here. Attorney, yung DS 2019 ko sa 2 years extension ay walang nalagay kung subject or na subject to go home ko. So ano ibig sabihin nun? So then again, ma'am, the officer still has the option or the opportunity to correct that the moment na i-apply ka ng extension or the moment that you will actually apply for a non-immigration benefit, whether an H-1B or other non-immigrant visa. Now, there are cases where some of the teachers walang not subject to pero nakakakuha ng H1B, nakakakuha ng green card because the officer relied on the visa stamp or the DS 2019. So what I would recommend though is in cases where you are a teacher from the Philippines, generally you are supposed to be subject to the 212E pero walang tatak ang nakalagay doon. I would recommend that you talk to the immigration lawyer handling your case because that lawyer might be able to give you some options on how to proceed as far as your visa stamping is concerned. From Danilo Castro, is there a case po ba na hinarang ang J1 visa sponsor ang process ng waiver? Kasi sabi po, once malaman. Yeah, okay. So this is a very good question daw. So it depends on what type of waiver you are actually applying. No? Kasi maraming waivers. Maraming grounds for the waiver. But the most common ones are the no objection statement coming from your home country of the government of your home country. In our case, it's the EVP in the Philippines. Okay? So, part of the requirement kasi ng pag-a-apply mo ng no objection statement is the certificate of participation or certificate of completion. So, ang pipirma sa document na yon is either your J1 sponsor or your training institution or your employer. Okay? So, ngayon, if ang gagamitin mo is ipapadala mo yung papel doon sa J1 sponsor, chances are the J1 sponsor will deny your request for a waiver because, again, it's not aligned with what their goals are. So, ang recommendation namin is you will ask your training institution to actually sign that certificate of participation or completion. At one point, the J1 sponsor will be notified by the Department of State that you've applied for a waiver or that your waiver has been approved. At that point in time, they even if they would cancel your J1 visa, you already have a waiver and you're already ready to change status to an H1B or immigrant visa. So it becomes irrelevant at that point. No? Kasi nga, meron ka ng waiver. The other type na popular din is the exceptional hardship. So ito yung mga cases where even if they are married to a US citizen or a green card holder, however, nag-divorce sila in the United States, they cannot apply for no objection statement. Walang requirement na certificate of participation or completion, but the applicant will apply directly from the USCIS, arguing exceptional hardship on the part of the petitioner, the US citizen husband or wife or green card holder spouse. As soon as the J1 waiver is approved, they will notify the J1 sponsor. So, just to answer your question, Danilo, may mga case ba? Yes, and it is the fault of the applicant because pwede naman pumirma kasi yung school. Kung hiningi niyang pumirma is yung J1, chances are i-deny ng J1 visa yan. And your J1 sponsor is so powerful that the moment that they actually have seen you apply for a waiver, they can cancel your J1 visa right away. I hope that I answered that question. We have here Geddy Gedsky. Sir, dahil may nakalagay sa akin subject to the 2-year home does apply, ibig sabihin uwi talaga ako after 3 years. Okay, so kung wala kang waiver, yes. At ito yung pag-uusapan natin mamaya, no? Yung mga waivers. Me, Aaron, what if may gusto mag-sponsor ng H1 but not teaching It's other work. Okay, very good question dito. Now, so may mag-o-offer sa'yo ng H1 but you are currently on a J1 visa as a teacher. Okay? And this applies to all other employment-based offers. So, the first step in filing a petition for a foreign worker is number one to determine if there is a legitimate offer and whether or not there is a legitimate employer. Okay, so pag once na pass mo yon kasi legitimate business entity naman yung petitioner or may kakayahan naman siyang magpetition and then the offer was legitimate as well. The second component doon is to prove that there is no U.S. citizen or green card holder willing and capable to do the job, and the applicant has the formal education, training, and experience to perform the job offer. So in this case, let us just say that the H1 was given an offer as a nanny or a caregiver. Let's just say for purposes of example. So, i-teacher ka eh. So, unless you have the formal training and education as a caregiver, then that won't work. You will not pass the eligibility requirement. So, for people who actually consulted us to say, what is the best chance for us to stay in the United States, assuming that we will obtain a waiver or we are not subject to the 2 years home residency requirement, then stay as a teacher. So, if you don't like your training institution, if you don't like your school, if you don't like your location, apply to other school or other location but stay as a teacher. So because that's your best chance to get another visa type. Okay, last na lang to, but then we will proceed. So Rose Ann Batag, ito na nakareceive po ako ng email from NVC that they will be working with the US Embassy Consulate in Manila to schedule an interview appointment. But then wala nga po akong waiver. I just need to tell them that I'm not ready. Okay. So, ma'am, if you receive an interview in the embassy but you have not complied with the 2-year home residency requirement, then you will be denied at the embassy kasi nga it's a requirement for you. But the other option for you to do though is pwede mong i-hold yung process na yon. An approved petition is an approved petition. So, kagaya mga nurses natin, their visa might have been their petition might have been approved years ago, and then they're just waiting for the visa category to be current. And even if yung visa nila is current na, you could still drag that process for whatever reason. You don't have the documents required by the embassy, or you are still working on your eligibility for some licenses or so on, then you could still drag that. So, but if you will push yourself now for the interview, chances are you will be denied. Okay? We'll go on sa sobrang dami, and thank you for tuning in. Hindi ko masasagot lahat ng questions but I'll try to go back later. Then let's try now to analyze the J1 journey, and this is the very reason why I actually put up this Facebook Live kasi we are receiving 3 to 4 consultations a day from the J1 teachers, and public-balik yung issue, so might as well share it on a Facebook Live. Okay, so this is the J1 timeline, right? So you are 5 years, initially you are given 3 years, and then 4th year, depende na sa training institution mo or the J1 ano strategy nila, whether they give you a yearly increment or whether or not they will give you a 2-year increment as far as your extension is concerned. But again, the law gives you 5 years. So maximum duration is 5 years unless government extended by the government. So just like this year, because of the pandemic, the J1 teachers who actually had whose visa expired in June were actually given a one-time extension, so they are not enjoying their 6th year. Okay? So, how will a J1 visa end? So, ano ba yung mga reason bakit mag-expire yung J1 visa? So, again, alam na natin na 5 years maximum yon. But again, ito yung sinasabi natin, when the visa expires. So, either it expired on the 3rd year, it expired on the 4th year, hindi ka na ni-renew, and then expired on the 5th year. Okay? Second, contract, the visa is pre-terminated for whatever reason. And we've heard some, but very rarely, right? Kinancel ng training institution or ng J1 visa sponsor mo because there are performance issues ng applicant or nag-breach of contract, right? Hindi inabandon na, the program is pre-terminated for funding issues, or nag-resign, or inabandon na yung work, hindi na bumalik. So then the contract and the visa could be pre-terminated by the training institution or by the J1 sponsor at that point. Now, death of the primary applicant could also result into the J1 visa expiration or the end of the program or yung visa na yun. Law, policy, and regulation changes, just like what Trump did, they actually suspended the J1 visa or the H1 visa could also affect the validity of your J1 visa. Extraordinary circumstances, just like the pandemic, right, could also result into visa expiration. So, ito na yung specific, and let's take a look at this very carefully, no? Because people commit mistakes that could actually result to fatal results, right? So, example, if you are already in your first year or second year on a J1 visa and you are subject to the 2-year home residency requirement, and then you got married to a U.S. citizen or a green card holder, you could apply for exceptional hardship waiver, whether regardless kung single ka or nag-divorce ka sa US. And once you have the waiver, you can apply for your green card, your spouse visa, work, and travel permit. However, if your J1 visa is terminated, at that point, you have no choice but go home. Or you could actually work with your J1 sponsor and ask why your J1 visa is terminated and if there's a possibility for it to be reinstated. However, kung kunwari nag-resign ka, then at that point, you have no choice but resign. But go home. Okay? If you look up into these choices here, sinabi namin na you cannot apply for the no objection statement or the NOS whether may anak kang US citizen or you are married to a US citizen. Okay? Ano bang reason bakit hindi? Because one of the requirements for you to apply for the no objection statement is that you have completed 75% of the program. So, ibig sabihin nun, if you are given initially 3 years, you can only apply for no objection statement after the second year. Kaya, when you are still in the first year on the second year, you cannot apply for no objection statement. So, ano bang ibig sabihin nun? Subject ako for 212E. Nagkaanak ako ng US citizen. Can I apply for no objection statement? No, not in the first 2 years. Nag-asawa ako ng US citizen, single ako sa Philippines, can I apply for no objection statement? No, because again, you have to comply with the 75% completion of the program. Can I apply for an H1B kasi inofferan ako ng school? Or can I apply for other non-immigrant visa? No, generally. No? Kasi nga, you cannot, no objection statement is not available for you during the first 2 years. Okay? However, exceptional hardship waiver, kasi may mga cases where yung asawa ko taga Texas but I am in New Mexico, gusto na niyang magsama kami, then I will resign from my school, the J1 sponsor will cancel my visa, anong gagawin ko? So in that particular case, you have to apply for the exceptional hardship waiver. Once the waiver is approved, then you could actually apply for your green card. So what happens now if I am not subject to the 212E? Okay? So, swerte mo, no? Kasi kung hindi ka subject to the 212E and you get married to a US citizen, then you could apply for the green card, spouse visa, and work and travel permit right away. Sir, J1 visa ako, hindi ako subject, but inofferan ako ng H1. Go ahead because hindi ka subject to the 212E. But careful with what I've said earlier. The moment that you apply for an immigration benefit, the officer reviewing your H1B application may look into the program details and may come back to you to say, by the way, you are subject to the 212E and your H1B will be denied. So, ito yung sitwasyon na sinasabi ko kanina na if you are not subject to the 212E and you would want to apply for an H1B, might as well that you consult your lawyer on what's best for you. Okay? Because at any point in time, the person reviewing your case will ask for an advisory opinion from the Department of State. Adjustment of status from H1B to green card. So halimbawa, nag-J1 ka, not subject to, then naswerte ka, nakakuha ka ng H1B, pwede ka na bang mag-apply ng green card? Yes. Okay? So tuloy-tuloy na yan. Okay? So I hope that this clarifies the question and I will answer some questions kasi very very specific yung year level kung ano ba ang dapat mong gawin as far as applying for a waiver, accepting an H1B offer, or applying for a green card. at kung pwede ka na bang mag-apply ng no objection statement. So, I hope that clarifies that. So, I will skip that slide for a while and then I'll try to answer some of the questions here. Emmanuel Ariola, okay? Ang daming galit. No? But anyway, maraming nagagalit sa akin dito sa Facebook Live. But anyway, Emmanuel, attorney, I have two questions. What other situational examples accepted for exceptional hardship aside from two examples mentioned a while ago? Again, most exceptional hardship generally applies to U.S. citizen spouse or a green card holder spouse. But in rare cases, but I would say applying for exceptional hardship on the spouses alone is hard already, exceptionally hard. But there are cases where you're gonna apply for exceptional hardship on the part of a U.S. citizen child because kung dadalhin mo yung anak mo sa Philippines, then you could actually mention economic reasons why it will be exceptionally hard for the child to live in the Philippines because may sakit ba yung child, may health issues ba siya, it could be opportunities for better education or because she's enjoying a lot of freebies in the United States but if you go back to the Philippines, wala ka na nun. But again, it's a case-to-case basis. But to answer your question, it can also apply to exceptional hardship on the part of the U.S. citizen child. Number two, in the case that a J1 participant finished his or her contract and decided to go home to spend 2 year home in the rule and has already been residing for 2 years, can they apply for NIW or a green card? In that case, sir, if you've already complied with your 2 year home residency requirement, I will expand your question. I don't encourage you to enter into another J1 visa or enter into another H1B or the national interest waiver, right? What the best thing for you is to contact your potential employers, right? Kunwari, yung previous employer mo, kung na-impress naman sila sa performance mo, you could actually ask them to sponsor your green card even before you leave on your 5th year. I'm going to talk about that in my last slide, okay? But to answer your question, once you comply with the rule, I would discourage you to apply for another J1 visa because we've seen teachers who have done that. You can apply for another H1B or you can jump into the green card right away. The National Interest Waiver NIW is another non-immigrant visa. It's a very high type visa type, and we have had cases approved for that. But I don't think that's the best option for you. Daryl, kung wala po asawa sa Pinas, pwede po ba NSO? Pero kung may dinidivorce ka po na kasal, ang dapat po gawin, hardship po. Okay. So if you're single in the Philippines and you got married in the United States, then the best option for you is the no objection statement. But you cannot do that during the first 2 years kasi you will not be eligible. Pero kung nag-divorce ka, going back, even if you're single, you get married, but you are still in your first and second year, at hindi ka talaga makapaghintay ng third year mo, then you have the option of applying for exceptional hardship. Mas complicated, mas mahal, mas matagal, but that will still give you a waiver kung magaling yung lawyer mo. Okay? Pag nag-divorce ka, wala ka talagang choice. Whether you are in the first year, second year, or 5th year, you have to apply for the exceptional hardship. Okay, so again, I will entertain some questions here because this is the purpose of why I put this live anyway. Neslia, how about po for those hoteliers, J1 visa holder, umuwi po kami na hindi natapos yung contract because of the virus and now we want to go back in the any option or move na pwede namin gawin po, attorney? Okay, so for the HRM group, okay, you have to work with your J1 visa. Kung hindi nyo natapos yung kontrata nyo, I think once everything normalizes, they will be able to come back and to complete your contract or your J1 visa duration. But we understand now that even the United States still has issues with the pandemic. Some of or majority of the hotels and the restaurants are still not operating as normal, and that's the primary reason why they cannot bring you back. But ang recommendation ko sa inyo is work with your J1 sponsor as to what your other options. Joji Chai, attorney, what if the school offers us H1B visa and yet we don't have any waiver like American Baby? Is it possible that the federal government could No, ito yung sinasabi natin na IGA, right? The Interested Government Agency. In the case of the teachers is the Department of Education, but they are not willing to sponsor waivers for now. Okay? So ito yung sabi natin kanina. If you don't have a waiver and you are the first year, second year, then it's not the best time to put your resources on because madi-disappoint lang kayo. Regine, after obtaining H-1B, can we apply for a green card right away or is there a minimum number of years to wait before applying for it? Good question, right? So you have the H-1B, and then the question now is, can you apply for a green card immediately? It becomes a company policy or a district policy, right? So when you are on an H1, you are allowed to stay up to 6 years for on the H1. Then normally on your fourth year, fifth year, the employer will decide whether they're gonna proceed with your green card application. But if the school district is very generous in saying, yeah, after 4 months or 2 months on your H1B, and they are now willing to start your immigrant visa, yes, you can do that, right? There is no restriction between transitioning from H1B to a green card application. So it really depends on the school district or your employer if they want to start that process immediately. Mayflower, attorney, what if twice po up ko nag J1 visa holder? What is my next? Okay, so if you are if nakatanggap ka ng J1 visa holder na different programs, then you are subject to the 212E, then you might be subjected to the 2-year home residency requirement, no? So ma'am, I would recommend if you could actually in more details with the lawyer anong best option mo, but generally speaking, kung twice ka nag J1 at hindi mo pa na-comply yung dalawang J1 na yon na different program siya, then you might be subject to the two-year home residency requirement. Maria Ramos, is there any chance that the J1 regulation may change since we have a new administration? General rule, only Congress could change immigration rules, right? But again, the president could change policies and directions. So who knows, no? The House of Representatives is now being headed by Democrats, and you have a Democrat president. Who knows, right? So we're hoping that there will be changes in immigration law because that's what they're planning or offering anyway. Winston, Attorney, good eve po. While on 2-year home residency, hindi ba pwede umalis ang Pinas for tour? While on 2-year home residency, ayun, kung bakasyon lang, walang problema yan. They will not take it against you. Ang the officer will actually look into the actual number of physical presence in your home country, no? So siguro yung mag-a-adjustment lang sila doon, but no, you can still go on vacation while in a 2-year home, complying with your 2-year home residency. Wendy Abendan, a J1 visa on 4th year, can a US petition a J1 dependent through K4 visa? Okay, ma'am, pagdating na natin doon sa 4th year, babalikan kita ha. We are still on the 1st year, 2nd year. Wendy Marcel Panganiban, how long po it takes to process a waiver? No objection statement, assuming that it is not suspended. It could take 1 month to 3 months depending on pag-submit mo, nagkaroon ng schedule ang EVP Manila to review your process, and I'm talking about the no objection statement, and then nagkataon na it was in the same schedule that they will forward approved cases to the Philippine Embassy in Washington, D.C., and then on time din ang pag-forward nila sa review division, it could take 1 to 3 months. We have cases like that. However, in the case of exceptional hardship, yun, medyo madugo, no? It could take between 7 months to 9 months, in some cases a year, depending on how difficult the situation is. Antoinette Portavida, before I go to the 3rd year. Attorney, paano pa kung ang employer ng J2 dependent ang mag-sponsor ng green card? Okay, again, going back to my basic principles kanina, the restriction on a J1 applies to a J2. So again, if you are in your 1st year, 2nd year, and you don't have a waiver, walang mangyayaring H1B, walang mangyayaring green card, right? So you really have to go back to obtaining a waiver before an H1B conversation or green card conversation can be had. Okay? Now, going to the next slide. Now, this is a little bit intriguing because the rule says if you don't have a waiver, you are not allowed to entertain an H1, or you cannot obtain an H1B, an L1, or get a green card. But it doesn't contemplate, or it doesn't say other types of non-immigrant visa, just like the tourist visa, the student visa, and the O1 visa. The O1 visa is the extraordinary ability visa. Okay. Uh, and I've seen and I've known some of my previous clients who have obtained this without being asked of a waiver. But the last 2 years, though, once you are subject for the 212E, and nag-apply ka from J1 to tourist visa or J1 to a student visa, then you will receive this. USCIS will send you a letter saying you are subject to the 212E and you are applying, in this case, J1 to B, to give us a proof that your visa waiver has been approved. If not, we will deny your case. So again, it depends on how the lawyer will handle the situation. Either they will argue that, hey, the rule says it doesn't cover tourist visa, student, or O1 visa, or they will just comply and say, hey, you know what, you need to go back and waiver, submit an approved waiver. Arivalo, attorney, what if po ang anak ko na J2 ay na-offera ng scholarship sa isang university and we're in our fifth year and subject to go home, what will happen po? So, man, and again, I've seen this case before. Again, there are cases where USCIS is more lenient towards approving uh, J2 applicants below 21 years old, while the J1 visa is still valid, that they would actually grant exceptional approval on the student visa. But even if the student visa will be approved on your J2 anak, once the student visa, once the program is finished, ibig sabihin, nag-graduate na siya, and may nag-offer ng company sa kanya ng job, he will still be subject to the 2-year home residency requirement. So, here's two possibilities in your case. Apply still for a waiver, apply for the change of status to USCIS, argue your case while it will be exceptionally hard for your applicant. Again, the rule says that doesn't cover F1 visa. If they will be approved, then you are lucky. But then, after matapos niyo yung program na yon, and then mabigyan siya ng job offer, then doon papasok yung subject to the 212E requirement. But, ma'am, try your luck, or at least take a chance on that. May follow-up lang si Mayflower. Same program po at nag-comply po ako ng 2 years sa first visa ko. This is my fourth year as J1 visa. Okay, so kung nag-comply ka na doon sa first 3 years mo, ma'am, and then on your fourth year, ibang visa program naman ang kinuha mo, and you are subject to the 212E, then you are now required to comply with another 2-year home residency requirement. Okay, moving along. Sa third year na tayo, no? Ano ko lang dito si Sober na Mina. Hello po, attorney. I am on my third year now and I am already 59 years old. Can I apply for a waiver by now? Oh, wow, ma'am. Kung based sa picture mo, ma'am, para kang nasa 30 lang, no? But that might be good news for you because the no objection statement actually says that if the applicant is 60 years old, and then the AVP may consider giving you a no objection statement. So ma'am, 1 year na lang ma'am. Since suspended pa naman ang no objection statement until July, so I don't know when your birthday will be. Hopefully, you are already 60 by the time that the NOS suspension will be lifted. Okay? Then argue your case. Kasi the good thing about the 60 years old kasi is you could basically argue that you go back to the Philippines, you are already 60 years old, it will be difficult for you, exceptionally hard for you to compete with the younger generation. You are already retired at that point based on age. So then chances are the AVP may grant you a no objection statement. So good luck on that. Okay, pasensya na talaga, hindi ko na masagot lahat no, sa sobrang dami. We actually have consistently more than 600 viewers, participants in our Go Live today. So thank you very much. So again, don't forget to subscribe on my YouTube because I will be posting most of my videos there. From Rochelle, my host school is actually an Indian school. The school would want me to do the best to keep me. Can they actually apply for the waiver for me? So ma'am, ito yung sinasabi ko kanina na I am actually contacting the Bureau of Interior because yung Indian school is actually part, structurally they don't report to the US Department of Education, but they actually report to the Bureau of the Department of Interior. However, we tried to contact the Department of Interior. They don't know what I'm talking about. No, so the Department of Interior is part of an IJA, is an IJA participant. There is a contact person there, and I am sending a letter to her if they will actually now support a waiver application by the teachers working in Indian school. So, ma'am, definitely if that will push through, I will have another Facebook Live because there's a lot of schools under the Indian school system in the United States. Ariel Belsa, if the state or district requires your skills like along research, pwede ba maging waiver yan? Let me understand. If the state or district requires your skills like along research, pwede ba maging waiver ma? I'm not so sure if I understand fully the question though. So, again, your positions, if you're a math teacher, if you are a science teacher, and or in an English teacher, right? So if doing research is part of an additional requirement, no, that cannot be a basis for applying for a waiver. But you might actually be going towards the exceptional, the extraordinary ability waiver. So let's just say, for purposes of conversation, and again, I apologize if I didn't understand the question correctly. Um, you are an exceptional teacher, you are a math teacher, and you brought your school to national contest championship. In that regard, I would want you to talk to an immigration lawyer because you might qualify for another O1 visa, which allows you to stay longer in the United States. An O1 visa is a type of visa where you can actually just keep renewing and renewing for as long as you keep the O1 visa eligibility. Ibig sabihin nun, you still be able to actually show that you are an exceptional teacher. You keep getting awards whether domestically or internationally. But the problem with this though is the moment your employer decide to apply for a green card for you, then the issue of the waiver will come back to you. Okay? So, ma'am, Sir Ariel, sorry, you can just send me a message because I need more details of your question. May Nelly, in the middle po sa 1 to 3 years, pwede po bang makuha mga anak at husband sa J1 visa po? Yes, they are called J2 visa. So again, you could bring in your spouses and children, unmarried children below 21 years old. So, okay, so going back na ako dito ngayon sa slide natin. So, you are now on your third year. And again, if you have questions about, if you are on the first year, second year, just go back to my presentation and you'll be able to review the slides, okay? Third year ka na. You are subject to the 2-year home residency requirement. What are the options for you to be able to obtain a waiver? In this regard, you can apply for an no objection statement if you are married to a U.S. citizen or a green card holder. Okay? However, if you got divorced in the United States and you are married to a U.S. citizen or a green card holder, you cannot apply for no objection statement, but you can apply for an exceptional hardship waiver. If you got terminated, you have to go home or you talk to the J1 sponsor for reinstatement. If you resign, you need to go home, else you will be incurring unlawful presence. However, in this case, nagkaroon ka na ng anak. Of course, you could apply for no objection statement waiver because at this point, you already have complied 2/3 of your program. So that's basically 75% of your program then. So then, once you have the waiver based on a U.S. citizen child, you can accept any offer on H1B, L1, O1, B2, F1, even for a green card. But again, meron lang timing issues and there might be an intent issues when you actually jump from J1 to a green card. I would recommend that you talk to a lawyer when you transition from J1 to green card immediately. But again, if once you have that waiver because you have a U.S. citizen child and you are on your third year, then you might be eligible for the no objection statement. But mag-bat mo na ako and then I will jump into the next slide. Nagkaroon ka ng anak on the earlier part of your third year. Okay? So now, so let's just say na nabuntis ka, nanganak ka on first 2 months ng third year mo. So you can apply for a no objection statement waiver and meron ng H1B na naghihintay sa'yo. If the employer is cap exempt, so ibig sabihin, they don't have to wait for the March and the March-April lottery, and they can file the H1B for you. And H1B can be premium process. Ibig sabihin, once we got the labor certification application certified, the H1B can be obtained in 1 month due to premium processing. Then you don't need a 2-year extension because you are already on H1. If you have a dependent spouse, children, they will be on H4. The only difference though is once they change from J2 to H4, they cannot work. So you might end up being the only person in the household having to work. Now, why is it important that you have to be very careful applying for a waiver on your third year? So remember, you are allowed on a J1 to stay in the United States up to 5 years. If you apply for a waiver prematurely, and then walang H1 na nakaabang sa'yo, or let's say you are already on your 10th month or 11th month, you apply for a waiver, pag-apply mo ng extension ngayon, then the J1 sponsor will say, sorry, we cannot extend you because you already applied for a waiver. And that is correct. Anong reason doon? Again, the J1 visa, you said, I agreed to enter or participate on an exchange program. And I also agree and understand that after the program ends, I will go back to the home country to be able to actually share my knowledge and expertise and experience. But here comes you, and now here you are applying for a waiver kasi nagkaroon ka ng anak. The fact that you applied for a waiver actually give the government that you have the intention of now not going home, but finding a way to stay in the United States. And that's the reason why your J1 sponsor will deny your 2-year extension. And I've actually talked to at least a number of people who have done that. They were too excited to have a child, and of course, you cannot blame them, right? They are just also as just like any one of us who would want to find ways to stay in the United States. Ang problema nga lang, siguro hindi sila na-advise dito that the moment that you apply for a waiver and you have not obtained your 2 years extension yet, then the 2-year extension application will be denied. So, klaruhin ko lang, if you are in your third year and you have a U.S. citizen child, before you apply for a waiver, consult a lawyer if it is a good time. But in the safer side, I would recommend that you wait for your 2-year extension approved first before you apply for a waiver. So kahit na nagkaanak ka pa, no? So nagkaanak ka ng first year, second year, then apply for the waiver, no objection statement in the earlier part of your third year. But pero kung nasa gitna ka na ng third year mo or nasa later part ka na ng third year mo, do not apply for no objection statement waiver because chances are your 2-year extension will be denied. Okay? So yan, klaruhin ko lang. Nagiging passionate ako because ang daming mga cases na nadi-deny dahil they applied for the waiver prematurely. Okay? So ano naman ngayon kung you are not subject to the 2-year home residency requirement? So again, if you actually notice whether you are in the first year, second year, or third year, if you are not subject to the 2-year home residency requirement, the options are pretty much the same. You could apply for a green card, you could apply for an H1B or any other type of non-immigrant visa or work visa, or you could apply actually for a green card through marriage, no, or green card from H1B to immigrant visa. So again, that actually just gives you more options. So again, going back tayo dito sa mga tanong, I hope nasa third year na tayo, no? Kasi tapos na dito sa first year. Okay. Si Suber, okay, nasagot ko na ito kanina. Sir, Adriana, question. J1 teacher subject in my third year or should be better on my fourth year? Should I apply for a waiver for me? Okay, so ma'am, I actually just answered your question now. No. So in your case, hintayin mo muna ma-approve yung 2-year extension mo. Once you have the 2-year extension approved, apply for a waiver, whether it's based on having a U.S. citizen child. My J2 dependents on the same time. I mean, should we be just... Okay, so the good thing about the waiver though is once you get approved for a waiver, then your spouse or children kasama na sila doon. Hindi na nila kailangan mag-apply ng iba pang waiver. So they're already covered by that waiver. Paul Andrew, can J1 visa apply directly as a green card holder? Technically, no. Because again, you might have a problem with the officer at the green card interview. Because again, the intent of the J1 visa is for you to go back to your home country. Now, if you apply for a green card right away, the officer might accuse you of fraud because you violated the terms of your J1 visa. But there are cases where you could actually apply for a J1 to a green card. I would recommend that you talk to your immigration lawyer on how you're gonna pass that intent challenges by the U.S. immigration officer. But possible, yes. Easy, no. Okay, but have your bases covered. Talk and work with your immigration lawyer. Sinon, good evening po. I'm on my third year as J1 visa. When is the best time to apply for extension? Normally, the J1 sponsor will actually facilitate that. Technically, they are supposed to be applying for extension minimum 3 months before your J1 visa expires. What we've seen is that fifth year, 5 years, 5 months, 5 years, 5 months, 6 months before the J1 visa expires, ina-apply na nila na extension. Okay? Para tuloy-tuloy na tayo kasi meron pa tayong fourth year, fifth year. Okay? So, fourth year, fifth year na tayo dito. I will just maximize my slide. So, what if you are now on your fourth year and fifth year? So, ibig sabihin na approve na yung visa mo na extension and now you are enjoying your last 2 years in the United States on a J1, J2 visa. And then, ano bang pwedeng waivers mo ma-apply? You could apply for a no objection statement and then apply for the green card based on marriage to a U.S. citizen or a green card holder. If you are divorced in the United States, then you can apply for exceptional hardship. So, ano bang, just to summarize this now, so if you are divorced in the United States, whether you are on your first year, second year, third year, fourth year, fifth year, you cannot apply for a no objection statement. Your only option is to apply for exceptional hardship. Uh, if you have a U.S. citizen child, you can only apply no objection statement on your third, fourth, and fifth year, hoping that you will get an H-1B afterwards. But uh, generally speaking, dapat nakakuha ka ng waiver based on having a U.S. citizen child only after your 2-year extension has been approved para hindi ka magkakaproblema. If your J1 is terminated, again, you can be reinstated or you have to go home. If you resign, you need to go home. Okay? Again, if you are not subject to the 2-year home residency requirement, then you could do all those things. You can apply for a green card, you can change status to H-1B, or you can change from H-1B to a green card again. Okay? So I only have 2 slides left. So if you are still staying with me and there's about 700 almost viewers, I think the topics that we've been talking is interesting as far as you are concerned. So I will just spend time answering questions here, no? Para hindi naman nasayang yung iba. Alfred Santos, sir, I'm already on my fourth year here in the US and I'm a teacher po and my visa said I am not subject to the 2-year residency. Okay, ma'am, so you're already in the fourth year. So ibig sabihin, the officer that reviewed your DS 2019 when you actually apply for extension agreed that you are not subject to the. Can I apply for H1? I would recommend that you do. Okay? So, boss, good luck on that. You will have chance of getting your green card or H1B. But again, that's good sign that you will be able to obtain those immigration benefits. Ito interesting to kay Bain William. Is J1 is not subject to but J2 is subject. Need po ba ng waiver for that? So, let's just assume that the officer of the Department of Homeland Security has concluded that the J1 is not subject to the 2-year home residency requirement, but that the J2 dependent is. You may still want the J1 applicant to go ahead and apply for H1B and later the green card. But unfortunately for the J2 dependents, they have to go back to their home country, comply with the 2-year home residency requirement. If at that point in time, na-comply na nila yung 2 years, and then yung J1 is still on an H1, they can file an H4 visa for them. Or if at that point in time, green card holder na yung former J1 mo, then he or she could file an immigrant petition for them based on family-based petition. So papasok sila, green card holder na rin. So again, if that sounds complicated, I would recommend that you have that conversation with the lawyer handling your case. Mark Hill, kapag na-approve po ang 2-year ang extension, okay lang po bang umuwi at dadaan? Yes. So let's say you're on the fourth year, fifth year now. Your 2-year extension, the 2-year extension has been approved. You go out sa United States, umuwi ka ng Philippines. Of course, yung visa mo expired na. You have to schedule an appointment with the embassy for stamping only. So chances are you will receive your stamp because they will base it in your the new DS 2019, and then you can come back to the United States. With the J1 visas still being suspended by virtue of Trump's executive order, I don't recommend you to fly out of the United States at this time, but maybe next time when the suspension is no longer in effect. Good luck on that. Mats, during fourth year, fifth year, or extension period, pwede po bang mag-apply ng J2 ang spouse and child maski expired na ang initial 3 years visa? Yeah, Max, once na-approve yung 2-year extension mo, you will be given a new DS 2019. And for purposes of pasundin mo yung J2 spouse mo at children to have their visa at the embassy, papadala mo lang yung DS 2019 mo na bago. And the embassy will give them a J2 visa based on that DS 2019. Of course, there are other documents required at the interview sa embassy, but yeah, they can obtain their visa based on the extension. I didn't care. I'm on my fourth year attorney and I have applied for exceptional hardship with my US citizen child and now waiting for the result. Question, can I also apply for an objection statement the same time with the EB or reopens? So, applying for a waiver based on the objection statement is a ground, and then applying for a waiver based on exceptional hardship is another ground. So, kung ma-approve ka ma'am sa exceptional hardship mo, then there's no purpose of applying for the no objection statement. However, purposes of conversation, madi-deny yung exceptional hardship mo based on the US citizen child, then you can still apply for another waiver based on no objection statement once the suspension is lifted and the EVP opens. So I hope that that answers your question. So exceptional hardship normally ma'am nasa 7 months, 9 months yun approved. Sometimes it can go over a year. 5 months is within normal processing time. Timmy Grace, I'm in my fourth year and married to a US citizen. Do you have any update on no? As far as I'm concerned, there is no development yet. So it is still suspended until June 2021. But let's just assume that it will be lifted at that point. You could still get a waiver, ma'am. Again, 1 to 3 months from the time you send your application. So you still have time if you have an H1B waiting for you. So let's just assume that the NOI suspension will be lifted by June next year. You could timely file your no objection statement application. You will get a waiver by September. It will be on time for your employer to file your H1B for your premium process. You could basically have your H1B in a month. Good luck on that one. Justin, hi, attorney, I'm pursuing F1 PhD after J1 visa that's subject to the 212A and I'm still required to fill. I still required. So, ma'am, ito yung example na sinasabi ko kanina. By the rules, dapat hindi ka hahanapan ng H1B, ng waiver. We've seen cases before na from J1 subject to the 212E, nag-F1, it has been approved, but after your H1 visa, and then meron ka ng mga employment offer opportunities or green card opportunities, babalikan ka ngayon ng 2-year home residency requirement. So again, there's two options. There's two ways of handling this case, right? So you apply for an F1, you receive an RFE, request for evidence. You can argue it on the regulation side that says, hey, I'm not required to submit a waiver based on the regulations, or if you already have a waiver approved, then just submit that. If you don't have a waiver, again, the only option is to argue on the regulation side or aspect. Is the Philippines now accepting NOS? No, it's still suspended until June. Alan, is the... Okay, tama na yun. Okay, so moving on. I am now on my last two slides, right? So, what if you are on your fifth year or you are in your third year at ayaw ka nang i-extend ng inyong employer, right? Or for whatever reason, ayaw mo nang hanggang third year ka na lang and you don't have a waiver. If your visa expires on the third year at ayaw ka nang i-extend, you have no choice but go home. Because you cannot change status from J1 to tourist visa or J1 to student visa because hahanapan ka nga ng waiver. If you don't have a waiver, your application will be denied. And you don't want to incur unlawful presence because that might give you a problem later pag na-comply mo na yung 2 years mo and then you have an unlawful presence and then that might jeopardize your getting H1 or a green card application down the road. If you resign or you are terminated, go home. Again, if you don't have a waiver, just go home so as to not compromise your chance in the future. Now, the other options here though is, sir, love na love talaga ako ng employer ko at gusto nila talaga akong i-keep. The problem is wala kang waiver eh. So let's just accept the fact that you have to go home. And this is where we actually spent my time on the last 3 months. We've been working and I've traveled in some parts in some parts of the United States trying to educate the school and the superintendents and the leaders of our school districts that, hey, if you really love these employees, and they love Filipino workers, by the way, but the thing is they cannot have a waiver. So the reality is they need to go home. But if you want them to comply with the 2-year home residency requirement, then might as well the immigrant visa for them. So, okay? So, ito yung sad reality. And I understand where the teachers are coming from, right? Sir, uuwi talaga kami. Walang talaga kayong option. Ma'am, wala talaga eh. Right? So, then accept that fact. Accept that reality. But, there's still hope. You could basically influence your employer to say, ma'am, I will go home, comply with the 2-year home residency requirement, but at least you could start the immigrant visa process now. When you actually says immigrant visa, that actually meant the green card application. So I will explain that in a little bit in the next slide. Okay. So here's your reality, di ba? Uuwi ka talaga kasi wala ka talagang waiver. So let's just assume your visa will expire in June of next year. But you are still allowed to actually stay 30 days after your visa expires. So let's say you go home on July 30, 2021, and your new 2-year home residency requirement actually ends on July 20, 2023. Okay? Now, if your employer or the school district or the superintendent is interested of really you going back, you have to start the conversation of starting the immigrant visa process for you. The immigrant visa process takes long, and I actually write here the steps that your employer needs to go through, of course, with the help of an immigration attorney. You have to complete with the PERM process because teachers are covered by the PERM. So it means getting the labor certification approved. Once that's approved, it could actually take about more than a year, 6 months to more than a year, depending on how fast your employer will comply with the process. Then they could file an immigrant petition for you as a foreign worker, right? Immigrant petition from USCIS that could take about 9 months to a year. And then once it's approved, it will be forwarded to the National Visa Center. At ito yung tanong ni ma'am kanina, no, na nakatanggap na siya ng National Visa Center. And then, it will take them 3 to 4 months. By the time that you start this, up to the time that you would expect an interview, tapos na rin yung 2-year home residency requirement. So, based on this timeline here, so let's just assume the school, because it's already November, right? And then you go out, you're happy that you attended this Facebook Live, and then kausapin mo yung superintendents mo. As a matter of fact, there are already about 3 to 5 schools requesting a re-echo for them because I told them I have this Facebook Live. then they will decide to start the immigrant petition for those teachers na wala talagang pag-asa kasi wala talagang waiver, that they could actually start the green card application for them. So let's just say we will be able to start the process by January 15 next year, and tuloy-tuloy lang yung compliance nila dun sa requirements. By the time na uuwi yung teacher by July 30 next year, 2 years later, may nakaabang ng green card interview schedule sa kanila. So it actually means that, okay, I just had a vacation in the Philippines for 2 years, but now here I am, I received a letter from the National Visa Center that I will now have an interview. Now, in this particular case, lumalabas na ang timeline is June 4, 2023, kagaya ng tanong ni Ma'am kanina. However, makukomplete niya yung 2-year home residency requirement niya sa July pa lang. So what we will do if we were actually handling the case is just drag along the process, but we are not going to schedule an interview until the applicant actually comply with the 2-year home residency requirement. That is to ensure na makukuha niya yung green card niya. Okay? So you may not be able to see the details of what I wrote here, but in this slide, it actually just summarizes the situation where you are already in your 5th year at wala ka talagang waiver, right? What I would recommend you to do is talk to your employer to start the immigrant visa process while you are still in the United States. So anong ibig sabihin nun? Today is already November, right? And then your visa will expire in June. Take that chance from today until June to influence your superintendent who loves you, your principal who loves you, to say, hey, you know what? I'm willing to come back. I will be willing to wait for 2 years. But when I come back, you don't have to worry about these visa issues anymore because I will already be a green card. Now, in most of the superintendents and schools that we've talked to, the moment that they understand fully na, ganun pala yun. Hindi lang pala J1 ang option ko to hire Filipino teachers, that I could actually hire them directly on H1, or once they get a waiver, I could actually file them an H1, then later on a green card, and even if they will go home, I could still start the process for the immigrant petition for them. They are actually most likely start the green card application for you. So, sa mga nagko-consult sa amin, what we actually encourage them doing, and they've been doing that, is to set up another consultation with their school superintendent or their leaders in their school. We give them the opportunity to present things like this. The more the superintendents understand the immigration process or were educated about the immigration process, they are willing to start the immigrant petition for you because they know better now. Okay? So anong advantages ngayon? So yung mga mga nurses natin na, mga teachers natin na fall into the 5th year at talagang walang waiver na makukuha, don't lose hope, right? Because waiting for 2 years and come back as a green card holder is a lot in a better position than people who are offered an H1B, got a waiver, offered an H1B, but the school says, oh, I'm gonna maximize my 6 years before I will apply for a green card for them. Because in that journey, though, it will take them from H1B 6 years to become a green card holder, as opposed for you to wait for 2 years, then come back on as a green card holder. So, ito yung one of the reasons why we encourage the school superintendents or the leaders to, hey, start the process for them. If they really like them, they will go back to you 2 years later. The employer saves time on resources of training. They will save on visa processing fees because, again, if you're on a J1, they will spend time to extend that J1 visa. They will need money to change it from J1 to H1B. Now, if they could actually just jump from J1, you go home, they file the green card application, they come back as a green card holder, there's no more renewal, right? And in normal practice, the dependents, the spouses, the children, the schools won't cover the cost of the green card application for them. It's the responsibility of the applicant to pay for the expenses for the spouse and for the children. Now, if you have an employer willing to pay for them, then you are lucky, and say thank you to your employer because they are so generous for them to do that. In the case of the employee, they will come back as a green card holder. No more stress of dealing with, I'm a J1, after 5 years I have to go home, or if there will be issues about relationship, then they could be sent home because the J1 has been terminated and all that. So then again, don't lose hope if you're already in your fifth year and they are willing, if the school is willing to file an immigrant petition for you. Enjoy your time going back to the Philippines, stay there for 2 years. At the end of the day, you come back as a green card holder. So that pretty much sums up our presentation for today as to knowing what your options are after your J1 visa expires. And I hope I was able to give that clarification and guidance to you, right? So again, you have time to review my slides. You would know what options available for you when you are on your first year, second year, when you are on your third year, or when you are on your fourth and fifth year. So, but again, there are still about 600 plus viewers. I would spend the time answering questions, but that basically ended my presentation. So again, if you would want to have more updates on U.S. immigration, please subscribe to my YouTube channel, Caracal U.S. Immigration TV. I'm just going to answer questions here. And again, thank you very much for joining today. So let's see. Attorney, nakausap po ba ang CCSD about this? Clark County School District here in Las Vegas. Ma'am Mayflower, I cannot publicly talk about clients, potential clients, because of client lawyer confidentiality. So no comment on that particular question. Jocelyn Calderon, will the school district spend a lot of money to do this for us? Ma'am, very good question though, right? At the end of the day, it still boils down to budget. Okay? So, of the schools that we've talked to, ang budget period talaga nila is nasa first quarter of the year, right? So this is in preparation for the opening of the schools around August, September. So if you really would want to bring this conversation, now is the best time to have that conversation, right? So in the normal uh, working ways of working, you will have your performance review normally around December, November, right? And if you really would want to take advantage of, hey, you know what, you gave me a very good rating, can you file a green card application for me? Or can you file an H1B for me because I have a waiver or because I'm going home next year? Bring that conversation now so that if the school or the superintendent is interested of filing either an H1B or an immigrant petition for you, they can put that in their budget for the next coming years. At the end of the day, no matter how much your superintendent or your principals love you, if they don't have the money, they cannot petition you. So, very good question, ma'am. Thank you for bringing that up. But have that conversation, the earlier the better, so they can incorporate putting a budget in around March, no, when they actually deliberate on their budget, no. So, but to answer the question, are there school districts that that are willing to pay for the fees? Yes, we met some of them. Some of them may not have that a lot of money, but for as long as they comply with who pays what, that can still be done. There are visa expenses that can be shouldered by the applicant, but generally speaking, if it's an employment based, the employer should shoulder the fees. Okay, so inisa-isa ko na lang to. Justine, was there an incident where the waiver was denied and when appealed still denied? In that case, it's still possible to apply for a waiver. So there's a lot of possibilities, ma'am. No? So you apply a waiver, it was denied. You file an appeal, it could still be denied, right? And in that case, if I am the lawyer handling your case, I would really look into my strategy though, or whether or not am I actually getting the right basis of or ground of the waiver, right? So there are cases where they apply for the no objection statement, but that doesn't really apply to them because the more appropriate one is the exceptional hardship. So again, it really depends on your situation, and it's the job of the lawyer to determine what's best strategy for you. So I would, to answer this question, sorry, let me step back. The best way to handle this though is that the rules say if you will be denied on one ground, it doesn't stop you from applying another waiver based on another ground. So let's say you were denied on the no objection statement, but you may be qualified on exceptional hardship. If I am your lawyer, I may not choose to appeal your case if I know very well that there is no ground to appeal, but I would rather explore looking for other ways of filing a waiver. If you would want to discuss further your case, ma'am, send me a message then. Edmundo, sir, will it be possible that you can send me your presentation? I will not send my presentation, but you can review my Facebook Live. It's actually recorded on my YouTube channel or my Facebook wall. Thank you. Merlin, paano nagkakaiba ang teaching dito sa Philippines at dyan sa US? Ma'am, there is actually a Facebook group called Filipino Teachers in the US. I actually created that group. There's about 10,000 or 9,000 members now. But join that group because the members there are very generous in sharing their experiences, tips for new members or other members. Luna, is there such visa as E2B? Maybe you are talking about EB2. So EB2 applies to advanced degree holders or people who have actually progressive 5 years experience. So let's say in South Dakota, North Dakota, their special education teachers are required to have a master's degree. And if the employer will actually file an immigrant petition for them, then the best category for them is the EB2. The advantage of an EB2, EB is employment based. Two is the second preference category, which actually talks about the advanced degree. It's always current. You can if the applicant is in the United States, they can even apply for their green card immediately, right? Unlike for the EB3, so employment-based third preference that only requires a bachelor's degree, then that might take a while, right? So this month, the EB3 and the EB2 are in current status. So it means that if the EB3 applicant, the BS Math teacher in Las Vegas, is in current and lawful status and they have a waiver, they could actually apply for an immigrant petition or a green card right away. So that's what EB2 and EB3 means. But again, what the best strategy is, I would recommend that you talk to the lawyer handling your case. Georgine, attorney, what if magka-baby lawful US citizen with NOS waiver but employer will not sponsor green card or H-1B? Ano po bang pwede ma-move para hindi uwi ng Pilipinas? Ma'am, very good question. If you ask your petitioner or your school district that, hey, are you willing to file an H-1B for me? Or are you willing to file a green card for me? But they said, no, we are not going to do that. Ma'am, it's not the end of the world. Look for another school or another state that will offer you H-1B. With the H-1B and the J-1 being suspended now, ma'am, there's a lot of schools looking for teachers with waivers and they are willing to file H-1B or immigrant petition for them. So good luck on that. Catherine, Attorney, good evening. What if on my fifth year as J1, then my US citizen anak, what are the possibilities? Papauwiin po ba ako? Ma'am, if you are on the fifth year, just like on my presentation, once the NOS is lifted or the suspension is lifted in the AVP, I would recommend that you apply for the NOS right away. And then, kung ang fifth year mo ends in June, there is a way of ma'am trying to stay legally in the United States. I would recommend that you consult a lawyer as to finding that strategy, right? Because it's not a question of whether or not you're gonna get your waiver. You will get a waiver as soon as the EVP opens up or lift the NOS suspension. Mads, pareho po kaming J1 visa holder ng husband ko. Pwede po bang mag-J2 ang isa sa amin after 3 years, then after 5 years, isa naman mag-J1, the other is J2. I don't think, ma'am, that that's the best strategy for you, though. Because, again, if the two of you are J1 visa holders and both of you are subject to the 2-year home residency requirement, if the J2 will become a dependent, I just don't see the benefit of you doing that because you will I would even recommend that once you get a waiver, that the two of you will be applying for H1B, because switching from J1 to J2 and then J2 to J1 doesn't really give you benefit if you are subject to a waiver. Right. So, hindi naman siya kasi dito kung subject or a waiver. But, if you are not subject to a waiver, ma'am, I don't recommend that you go to a J2. You might explore other option, maybe an H1B for both of you, so you could still continue working. Princess, assuming H1 has been approved, is there a way, any waiting time to file for the green card? Again, it depends on your school when they are going to allow you to apply for a green card right away. What are the steps in availing a waiver? It really depends on your situation. I would recommend that you consult an immigration lawyer to explore your options. Alan, I'm on my third year and married to a US citizen. Can he apply a petition for alien relative even though we are still waiting for the NOS? For the I-130, yes, you can do that. But it doesn't really give you much advantage though, because at the end of the day, what will change your status or protection from being not deported, but for you to be sent home is the filing of the green card for the 484. But don't go ahead if you would want to file the I-130, but you would still need a waiver to apply for the green card. Okay? Benji, what if J2 ako, then subject to the 2 years, pero may work ako sa US, makasponsor ba yung employer ko for an extension? Sir, yung pwede lang mag-file ng extension to you is the J1 sponsor ng J1. So, yung employer mo, I would presume that you work on work permit. So kung sino yung employer na predetermined, they cannot file an extension for you. For the J1, only the J1 sponsor can file an extension for you. But kung kunwari nakakuha ka ng waiver, yung employer mo could file an H1B or an immigrant petition for you. Nicey, on my 4th year, pwede pa i-apply mga anak ko. Pwede po isabay interview ko for extension, interview for J2. Yes, ma'am. Once the embassy opens for the J2 interviews. Kim, I'm on my 5th year on J1 and my wife is on her 2nd year as J1. Can I apply to be her J2? Sir, once your 5th year, if you already have maxed out, then you have no option but go home, because you cannot be on a J1 and a J2 because you will be subject to the same restriction. I would recommend though, you seem to be, if you could find a way to find a waiver and then use that as finding a way of spending, staying longer in the United States. Inisa-isa ko na lang yung mga questions para lang at least I would. But it's already 11 o'clock here. I might just end by 11:10, maybe 10 minutes more, because there's a lot of questions. Hello to me, if you don't have a US citizen child nor a US citizen husband, what are the chances of being approved when you apply for no OS? Kung wala kang citizen, chances are you will be denied of an NOS. Exceptional hardship, if not based on having a US citizen spouse or US citizen child, is not a ground for you though. No? So again, ito yung mga situations really, sir, that you could look into the 5th year and then start influencing your school district to file an immigrant petition for you. Alfred, good evening, attorney. I have a son who is a US citizen. Before I had my J1 visa, is it still possible to apply for a waiver? This is interesting, boss, because the rules actually didn't qualify whether the US citizen child be born during your J1 visa or before the J1 visa. But if I will be your lawyer, I would still apply for the no objection statement, because, or if they will be denied on the no objection statement, I would apply for exceptional hardship based on the US citizen child. If I will be your lawyer, I would try that route. Kapag ang J2 kay Marvic, pag ang J2 ay mag 21 years na pero ang DS 2019 ay 22, ma-expired, Ma'am, you might have a very good chance of being approved exceptionally by USCIS just to be able to maintain their status. They will be granted a temporary F1, but then again, after that, they have to find a way of a waiver. So um, you might want to discuss that further with an immigration attorney. But you have a good chance of being approved on an F1. Maricel, clarify lang po, if there's a school from other state willing to sponsor you after 5 years, pwede na po ba yun as a waiver? No. Having a job offer from another school or from the same school is not a ground for a waiver, right? But sa ngayon, ang ina-accept lang talaga ng EVP Philippines, automatic grant based on having a US citizen child, married to a US citizen husband or a spouse or a green card holder spouse. If you are looking into the exceptional hardship ground of a waiver, exceptional hardship to the U.S. citizen spouse or green card holder spouse or U.S. citizen child. Other than that, you don't have a ground for a waiver. Ayan, what if po within 4 to 5 years my J2 turns 21, can he separately apply for a change of status? I would do that if I were you, right? So, ma'am, wag mo nang hintayin na mag-21 siya. Apply for a change of status now from J2 to F1 to be in the safer side. While the J2 is still valid. My students won a national mathematics competition. I am the coach. Sir, you might want to apply for an O1 visa. Send me a message, Mark. Wendy, I'm on my fourth year attorney follow-up sa tanong kanina that you said balikan natin. Can my US citizen spouse apply for K4 visa para sa dependent ko? K4, ma'am? I'm not familiar with the K4. Or wait ko na lang na approve ang waiver ka, sabay ko sila sa change of visa ko. You mean siguro, okay, so pakiklaro lang ng K4 visa. But if you're a J1, they are eligible for a J2 visa. And then once you have a waiver, you can bring them as an H4 visa pag H1B ka na. Or if you would want to apply for a green card, kasama na rin sila dun, ma'am, sa green card application. Doon sa extension not subject to po ako, pwede ba ituloy ang interview? You will be denied, ma'am, kung hindi ka pa nakapag-comply ng 2-year home residency requirement. So what if I were you, itadrag ko yung process, saka na lang ako mag-schedule ng interview pag nag-comply ka na doon sa 2-year home residency requirement. Justine, PhD, nasagot ko na to kanina. And again, so guys, it's already 11:12. And again, thank you very much. It's 12 noon in the Philippines. For more immigration updates, I will be posting it on my Facebook. And again, I just have difficulty having a YouTube live. But maraming salamat po sa inyong lahat. Have a nice day. Salamat po.